Hello and welcome to today's webinar, Practical Steps to Managing ATO Director Penalty Notices. My name is Michael Pollock. I'm Head of Content at Creditor Watch. And today I'm joined by Prue Greenfield, who's Principal Lawyer at Macpherson Kelly Lawyers. They're a commercial law firm with offices in Melbourne, Sydney, Brisbane and Dandenong. And Alice Rue, who's a partner at SMB Advisory, which is an insolvency and business advisory firm with 6 offices along the East Coast from Brisbane to Hobart. Thank you, ladies, for joining me today.
Thanks, Michael. Thank you, Michael.
All right, so just before we start, the usual housekeeping stuff, we would encourage everybody to send through questions. We'll try and address them where we can, but if not, rest assured we'll do that at the end of the webinar. And just a little bit about Creditor Watch for those of you who aren't familiar with what we do. We are Australia's leading business-to-business credit reporting bureau. We have more than 55,000 businesses that we partner with. We provide a credit risk management system running from everything from onboarding through to credit reports, monitoring and alerts, so you are alerted whenever an adverse change occurs to any of the companies on your watch list, and finally debt collection tools, which we hope you never have to use, but they are of course there if you need them. Now moving on to today's topic, director penalty notices. So obviously, during the pandemic, the ATO took a hands-off approach to debt collection, but the tax office is now ramping that up to the point where towards the end of the year, we understand it will be back towards pre-pandemic levels. There's around $60 billion of outstanding debt on the ATO's book, so it's quite significant. And if you caught our recent webinar with Claire O'Neill, the Deputy Tax Commissioner, with our CEO, Patrick Coughlin, Claire confirmed that they are ramping up firmer actions such as garnishees, court actions and director penalty notices, which of course we're here to talk about today. So on top of that, they are in the process of disclosing debts of more than $100,000 to credit bureaus such as Creditor Watch. So we are collecting that data and reporting on that data to our customer base. It's important to know though that it has been a trigger for, disclosures have been a trigger for businesses to pay off their debts. So of the 30,000 odd businesses that the ATO was preparing to disclose debt on, that dropped to 22,000 earlier this year once they were aware that the ATO was going to share the details of that debt. It's also important to note that the debt is only disclosed to the bureaus after the company in question has refused to communicate with the ATO. And once they do enter into a payment agreement with the ATO, we remove those records entirely from our database. So just a bit of background on how that's been working there. Now, on to today's webinar, director penalty notices. I guess I've spoken a little bit there about the state of play, but I guess Alice, if you just want to sort of kick us off and talk a little bit about, you know, what's happening in terms of director penalty note.
Yeah, and I think you have really well, thank you, Michael. You've gone through a little bit of the stats there. We might go on to the next slide if we can. Excellent. Actually, Prue, before I do, did you want to run through our agenda?
Yeah, no, absolutely, I can do that. And yeah, thanks, Michael and Alice. I was just going to add a little bit to what you said, Michael. Obviously, everyone's hearing everyone, their news feeds and in discussions with colleagues, you know, the ATO are ramping up activity. And as you said, Michael, you had a webinar recently with the Assistant Commissioner of the ATO and Patrick, where they spoke about what that activity was, and there was reference to director penalty notices and garnishee notices. And Alice and I thought it'd be a great opportunity, obviously, to talk about what that actually means, because people hear these things and they say, oh, okay, that sounds a bit, scary, or I'm not quite sure what to do. So we thought it'd be a good time to go through in detail and what it means actually practically for directors and how you deal with it. So that's why, we thought today would be a fantastic webinar to go through those details. So what we are going to look at, Alice is going to take you through what the current stats are, because they are increasing. We're going to look at what a warning letter is, because that's something that comes before the director penalty notice, and that's a really important stage. We're going to look at what director penalty notices are and the different types, because there are different types and they have different consequences, and how you deal with those, and practically looking at those as well and what to look out for. We're going to look at the liability of associates, former directors and new directors, because it's an important point to note that sometimes you think you may not be liable, but you can be. Alice is going to take us through the Small Business Restructuring Framework, which is some new legislation that was brought in early in 2021, because this is now an option that you can take in a non-lockdown director penalty notice, which we'll go through. And we're going to look, I'm going to take you through a legal decision, we just call it the Clifton decision, which changes the landscape in relation to payment plans and when you can enter into those. I'm going to also take you through defences, so if you ever need to raise a defence and what the different types of defences that you might be able to raise. Alice is going to look at garnishee notices, because that was referred to by the ATO as something they're doing. So it's really important to know what that means, when that can happen, in what instances for both individuals and companies. And then we're going to leave you with some practical tips and tricks to take away with. So I'll hand over to Alice now in terms of going through the recent stats, because they're quite significant. So over to you, Alice.
Thanks, Prue. And I'll just echo what both Prue and Michael have said in terms of the ATO activity. COVID-19 obviously led the ATO to suspending a lot of its activity. Most overdue tax collections were suspended. That was also compounded by the moratoriums put on in terms of the bankruptcy and winding up applications that were allowed during that time. So there was a real halt to the activity available for the ATO in trying to pursue its recovery actions. However, we're seeing that change quite a little bit at the moment. As of the 13th of May in 2022, the ATO had sent out 52,319 awareness letters regarding the use of DPNs. We're talking about warning letters today, and they are very much awareness letters to let people know what might happen if a DPN is issued, and we'll show some examples of those shortly. The ATO warned that it's currently issuing approximately 150 DPNs each day, and that's expected to continue to surge. So I'll just interject there, and it's something I'll probably call back to towards the end of the webinar, but from what I'm seeing at the moment, we get the daily wind-up list that comes through, and that has on it the winding up applications that are being made to court, but also it has on it all of the companies that have gone into liquidation, whether it be by a court order or voluntarily each day. And what I'm seeing is that the actual winding up application, so the court application number, they're not huge at the moment. They're not going back in any great strides to pre-pandemic levels, but the actual amount of winding up notices, so companies going into creditors' voluntary liquidation, they might be going into voluntary administration, they might be going into compulsory liquidation, so liquidations by the court, that's definitely expanded, and those numbers are actually getting back now to pre-pandemic level. And what that's showing us is that the AETO is actually still driving the liquidation level, but through the use of these director penalty notices. As you'll see in a moment, one of the only ways on a non-lockdown DPN that you can have that notice taken care of and really alleviate the personal liability is through putting the company into a form of external administration. So whilst we're not seeing the ATO as that winding up debtor or creditor, sort of attacking everyone in the courts at the moment, we're definitely seeing it as the catalyst for a number of these windings up that are happening every day. So with that 150 DPNs each day expected to surge, we can expect that that's going to continue.
It's really interesting, Alice, isn't it? It's something we were talking about, because you're seeing the insolvency levels increase due to service of DPNs, and which we will go through. Obviously, directors having to select an option, and one of those is an insolvency option. So it's a really interesting insight to say, okay, this is one of the reasons why that list is increasing. So yeah, really interesting.
Absolutely. So the ATO has also issued 1,500 intent to disclose notices following 29,552 awareness letters concerning liabilities in excess of $100,000. And we're aware at the moment of 50 clients owing more than $100,000 that have already been referred to client reporting bureaus. And Michael, you might be able to tell me that that's a lot more, but the ones that we sort of have seen through the official standards has been that there's been about 50. So it's happening. It's a real thing, and it's no longer a threat.
Yeah, it's around 50, but it's also, as I pointed out, it's a really powerful trigger to encourage businesses to pay off that debt. You know, if they know that they're going to be named and shamed, I guess, publicly, you know, that's a really powerful tool for the ATO, and it's, you know, of course, good for business generally if these businesses are sort of getting some kind of impetus to pay off that debt.
Absolutely. And one of the things I would say, and probably another reason to make sure that you have someone like Creditor Watch able to tell you when these companies are being reported on, I would like to, and Prue will probably agree, but maybe not, I would like to look at whether or not understanding if a client or a supplier to any entity has owed $100,000 or more to the tax office, has been reported on Creditor Watch, then goes into liquidation, whether someone like me could actually look at whether or not payments made after that reporting has happened could be looked at as preferences, given that the end user may have already known that the company was in distress. Now, that's obviously not something that's happened at this point in time, but if that's information that's aware or that's available to credit managers or that's available to different companies, I would think that a liquidator might use that in their arsenal in terms of, well, it's on the public record, they owed more than 100,000. You know, what was the reasons to think that they were going to continue? So I think that there's options there. Just moving on.
The other thing to note on that as well is that I know Patrick in the webinar asked Claire if there was any plan to reduce that 100K threshold,
yes.
And the answer was that you know, it's a issue for the government of the day. The ATO, it's not a decision for the ATO, but she did say that these policies are under constant review, and the mood in the business community is taken into account as well. So, you know, take that as you will, but, you know, the 100K threshold will eventually be under review, I guess, is what we can confidently assume.
Yes. No, I think that's very relevant.
Yeah.
All righty. Are we able to move on to the next slide, please? Thank you. So one of the things we really wanted to do in this session today is make it really practical and not just use a lot of words, but also show a lot of examples of what we're seeing and what's being issued by the ATO. One of the caveats I'll put on that is in the course of, you know, the last 12-ish months, we're seeing different incarnations of warning letters and of director penalty notices My understanding is that the level of authority to send director penalty notices from the ATO is sort of a lower level that is required to, for example, instigate winding up proceedings and these sorts of things. So there are a number of different interpretations that are being sent out. Prue and I will go through today and highlight what you need to look for director penalty notices, but it may not look identical to the ones that we're looking at today. So just be aware of that. Orange seems to be the flavour of the month. If you see a notification that has orange all over it, I think that's probably the first indication that there's something you need to have a look at. And this here is one of the warning letters, and we know that because it says warning. We also look at, it's a warning of a possible director penalty notice for an unpaid company debt. So what happens there is the tax office talks through what is actually the debt about. This one here is for GST and PAYG, and it talks through a director's obligations to be able to pay those debts. But then when we go down here, it actually looks at what you need to do. And it says you need to arrange for the company to either pay the outstanding amount or enter into a payment plan. And that's a really important indication that this is a warning letter and not a DPN. And noting that you should also contact the company's BAS agent or tax agent for assistance. And on page 2 over here, we also look at the amounts owed. We've obviously redacted these for obvious reasons, but it'll say what the payment reference number is and the amounts that are owing there. But that entering into a payment plan is an option that's only available at before the DPN is issued, and Prue, I know we'll talk about that in a moment. But that's one of the really important things to take away. So that's a good example of the warning letter. And I guess after the warning letter comes the DPN. So Prue, do you want to maybe chat about what actually a DPN is and how we look at those?
Yes, I will. Thank you, Alice. So yes, Alice is just taking you through the warning notice, which is something that comes before the DPN and is a perfect opportunity, obviously, to deal with the matter and be able to enter into a payment plan, because that gets taken away at this director penalty notice stage, which we'll go through. So a director penalty notice is basically where a company owes their PAYG, SCG, GST obligations. They either haven't lodged with the ATO or they haven't lodged and paid. And what can happen, and there's the two different ones which we'll go through now, is the ATO can then issue a director penalty notice saying to the director, if you do not pay or you do not enter into one of these options, which we'll go through in a moment, you are personally liable. So it's quite serious. It's, in legal terms, we call it piercing the corporate veil. So you have your company set up to protect you from that, liability and that exposure, but this director penalty notice can take that away if not dealt with. So it's very serious, obviously, and because we hear there's so many of them, it certainly needs to be that awareness about what it actually means and the liability. So I'm just going to take you through, we can go on to the next slide, Michael, the different types of director penalty notices.
Sure.
So there is the first one, which is the more common one.
Can we just make the point there, Prue, that directors can be liable for debts incurred before they actually join the company and also after they leave the company. Is that right?
Yeah, that's correct. And Alice will go into that when we talk about, on our associate slide. Yeah, so we'll go into that in more detail, but definitely that's something that we're going to make the listeners aware of, that it's not just, when you're currently the director, it can be in lots of different circumstances. So the non-lockdown DPN, and I'll get Alice to go through the example in a minute, because she's very good at that, and highlighting what the things are that you need to look for. But what a non-lockdown DPN, which is the more common one, is where you've lodged your tax returns within 3 months of their due date, but you haven't paid. So this is the most common occurrence where companies go, I'll go to my accountant, I'll lodge my tax returns, but I just can't afford to pay it. I don't know what to do. It's been really hard times, COVID, not sure what to do. And then if you're served with this, you have 4 options only. So that payment plan option is not available at this time. You either pay the debt in full, You appoint an administrator, so that's different to liquidation. So administrators, when you're trying to save the company in some way and see if you can go back to normal trading or it goes into liquidation, you put the company in liquidation and appoint a liquidator, or the new option of the small business restructuring regime, which Alice will take you through. So that's a new option that's been added. So there are essentially 3 insolvency options, or pay it. So that's why we're seeing this winding up list increase, because there's lots of companies that just can't afford to pay, might be $100,000, but $500,000 debts. So they're having to take this course. If we can then go to the lockdown DPNs on the next slide, that's where you haven't lodged, so the company hasn't lodged their returns and they haven't paid. So this is really serious, because your only option is to pay the debt in full. There's no payment plan. There's no option of taking away that personal liability by going into liquidation or administration. You can still do that. Obviously, that's always an option, but it doesn't take away that personal liability. So getting a lockdown DPN is very serious, obviously, because if you can't pay it, then you're personally on the hook. So it's really important to know what the differences are. So sorry, if we can just go back a screen, Michael, I'll just get Alice to take you through the what a non-lockdown notice looks like, and then we'll flick to the lockdown notice just to see what to look out for. So if I can just get you to do that, Alice.
Of course, thanks, Prue. And look, it's quite straightforward. Once you can see it, then you understand what it's there. So obviously, this is a notice of a director's liability to pay a penalty to the tax office. That's what it says. It's under the Tax Administration Act. So you'll notice that that's actually noted as a notice, whereas the other was noted as a warning. So there is a distinction there between the warning letter and the actual notice coming out. You'll also notice there down the bottom, this is how we know it's a non-lockdown DPN, is that you have the options and they are listed there, as Prue went through, in terms of either paying the debt or entering into one of those external administration options that are there. So that is a non-lockdown DPN. And Michael, if we want to go to the next slide, just to show the difference again, in a lockdown DPN, you only have the 2 options as highlighted here. So paying the amount or causing the penalties to be remitted. So basically that there means if you don't pay the amount or you don't have a good reason, and Prue will talk about defences in a moment, then you are personally liable. And again, it's very clear, you have been issued with a director penalty notice. So you can see that that's quite distinct from the warnings that we went through earlier. And it's quite, distinct in terms of the periods that either lodgements haven't been made or that amounts haven't been paid, and the type of debt in terms of whether it's super guarantee charge, PAYGW or GST. Thanks, Michael.
Alice, we've just had a question come through.
Sure.
And they acknowledge that it might be a bit hard to gauge this at present, but in your experience with clients coming through with DPNs, have you seen like directors of multiple companies being culpable here, or is there sort of like a serial offender type situation, or is it too early to gauge that?
There can be, and generally if you haven't paid in one entity and there is a group, then that group can be affected in terms of you haven't paid or lodged in one, then generally you haven't paid and lodged in a number. The tax office has, and we learned from the earlier Creditor Watch seminar with the tax office, they have an immense amount of data on everybody and how that all relates. And I'll going to talk to the next slide in terms of looking at associates and associates liabilities as well. And thanks for that. But that actually comes into being as well. So I do think not only are the tax office aware of those more risky clients, I guess, I think they do put a special emphasis on making sure that there is compliance across the board. Does that answer the question?
Sure. Thank you for that.
No, that's okay. So then just turning to that, as I said, so we're talking about director personal liability. That's what it's all about. It's a director penalty notice to make the director personally liable, as Prue said, and pierce the corporate veil. But it's not just the director. in these situations that can be affected. Associates can be affected as well. So these can be relatives, partners, spouses, children of the company directors. We also need to be aware of potential shadow directors and de facto directors as well, who are taking sort of those positions in the company and management positions there. And when you talk about, you know, sort of repeat offenders, as it were, this is, I think, one of the parts of the Act that the ATO does use very sparingly, and generally it's when there has been a history of non-compliance within. It might be a family group, or it might be a group of companies where there's been shifting of directors because one can't be anymore, they might be bankrupt or what have you. So it's obviously a very serious thought that as an associate, as a spouse, as a child, you could be liable for your relatives' direct penalty notice debt on a company that conceivably you don't have a lot to do with. But realistically, that nexus, I think, would need to be there for this to come into effect. But that being said, the associate also shouldn't be liable if they took reasonable steps to influence the payment and the lodgement in respect of those debts, or even reported to the commissioner themselves and trying to mitigate against that risk. But Michael, to what you said earlier, absolutely, former directors and new directors can be liable if there are outstanding amounts. If you are a new director into a company, it's really important that you understand the company's position insofar as non-lodgement or non-payment of the tax liabilities within 30 days. 30 days of your appointment. So basically, if you become aware within that 30 days of a DPN sort of event, then you need to act on that. Otherwise, you, as the new director, even if you weren't a director when it came into force, will be liable for that amount. So that's pretty serious. And similarly, if a director resigns from their position, they may still be personally liable for a company's unpaid liabilities that were due before their resignation. Or if they were, like, they resigned during a resignation. So if they resigned during a quarter and that quarter ended up being a non-lodgement or a non-payment quarter, then that director who has resigned can still be personally liable. So I think that goes through a few things. We might swap on to the next slide. Sorry, Prue, did you have anything you wanted to add?
No, I was just going to say, yeah, it's obviously very important to be aware of that. Definitely. Yeah, agree. I think we were just going to, talk about I spoke before about the insolvency options, and we just thought it would be helpful for people that don't know about it to just hear a little bit from Alice as the insolvency practitioner as to the newish small business restructuring framework and what that means, and I guess how much it's being used. It just might be some interesting information for the listeners.
Absolutely. Now, you're right, newish. It's been around over 18 months now, but it is still new. It's not being utilised probably as comprehensively as it was intended at the time that it was introduced. It is quite a different option from the usual voluntary administration and liquidations that we would normally look at. There are restrictions in terms of the company. It needs to be a company first, incorporated under the Corporations Act. It has to have liabilities that don't exceed 1 million. That's on the day that the company enters the process, and also that doesn't include employee entitlements. But a really interesting observation is that amount could change at any time. We think that the take-up of this option hasn't been as widespread because of that limitation in terms of the 1 million total debt amount. When you take into account security, secured creditors, etc., that's not really a lot. And that really closes this option off for a lot of companies. So I think that if that does increase, and there has been quite a lot of discussion around that, then it might be an option that is more readily used. The company needs to be insolvent or resolve that it's likely to be insolvent at some future time, and then they need to appoint a small business restructuring practitioner who is also a registered liquidator to basically facilitate that process. But once you enter into the process, the company stays in control. So sort of as an alternative to a liquidation or an administration where the administrator or the liquidator is then in control, this is very much a debtor in possession model. So the company directors remain in control during that process. the company needs to develop basically a debt restructuring plan, present that to creditors, and creditors need to resolve whether or not they will take that up, and the company can continue through that process. But you need to ensure. Oh, sorry. Yep. Oh, I can't hear. Am I?
Sorry.
That's it.
Can you hear me now?
Yeah.
Just curious to know, are there any other costs involved for businesses besides the cost of appointing the insolvency practitioner?
Look, it's always a cost-benefit analysis. And can I say that when this first came out, it was touted as a cheaper option, and it is not. In my view, when I've compared this to actual voluntary administration for options, it's generally the voluntary administration that gets taken up due to the certainty that's around that. But to answer your question, there is still very much a stigma in this country in terms of insolvency events. And whilst the debtor or the directors are still in control of the company, you may find that there are a lot of suppliers that won't continue to forward credit or advance credit once the company's gone into these processes. And that then makes it really difficult for the company to work through and hit the targets that it's set, because it can't get stock. It might not be able to, have other things supplied on credit, and the banks might then also call in certain debts. It can be quite a difficult process. So it's for that reason generally that where there are some complexities, in my opinion, at the moment, especially given that $1 million threshold, I do think that voluntary administrations, and we've seen an increase in voluntary administrations since this process was introduced. And I think it's because there's been a more of an appetite from a lot of creditors in terms of compromising debts, but in a more certain fashion with the practitioner actually in control. Does that answer the question?
Great. Thanks for that, Alice.
And so just really quickly on that, I was just going to say, so the benefits though do include the fact that the directors remain in control, and that can be something that is very difficult for a lot of company directors to let go of, and we understand that. So the practitioner in an SBRP is really just a facilitator of that process. All right, I think with the next slide, Prue was going to talk about a recent decision.
Yeah, so this is just a decision on the payment plan issue. So we just wanted to go through this because it's such an important, obviously, aspect of the director penalty notices that's no longer an option, that payment plan. So the impetus behind that was this decision called the Clifton decision. We'll just keep it really simple, not too legalistic. There was a company called Solar Shop that entered into a number of payment plans with the ATO. And the liquidator in this instance was successful in establishing that the due date for payment of the director penalty notice should not be varied by virtue of a payment plan. So it's not saying that you can't enter into a payment plan, but it just means that it doesn't take away that personal liability. So that 21 days does not stop running. The debt is still due and owing, and that personal liability still attaches. So the key takeaway from this decision, like we said, is for non-lockdown DPNs, the only options are what was set out, those 4 options, and the payment plan option is only really available at that early stage. So we're saying this a lot because it's so important, because we know there's a lot of struggling businesses out there and people that just can't pay straight away. So it's, the key message, in which we'll talk about at the end, is really to act early and deal with the notice. It's a very important decision and something to be aware of. So that sort of leads on to the next slide, Michael, if we can just go to defences. So
can I just weigh in really quickly, Prue? Yeah. Sorry, I just wanted to, with respect to those payment plans as well, it's my understanding that the tax office can't take steps to recover like a director penalty notice liability whilst that organisation is subject to a payment plan. That's right, isn't it? So that's why also it's so important.
Yeah, absolutely. Yeah, correct. Yeah. Yes, thanks, Alice. So we've spoken about obviously the options underneath these notices, but there are also defences available, and you can raise these defences upon receipt of a notice, and also if you ignored everything for whatever reason, which the first defence will go through, you can if legal proceedings were issued, you can raise these defences as well. So there's there's three sort of subcategories of defences. The first one is that you were ill or couldn't take part in the management of the company for some reason. So that's sort of a complete defence in a way, where if you can establish that, okay, you were in hospital for 3 months, or you had a very ill child, and you weren't taking part in the management of the company for that reason, you know, these are the sorts of defences that can be raised with the ATO, and they will consider them. There's also a second defence of reasonable steps, and this goes into sort of the non-lockdown options, where you can say to the ATO, look, I took all reasonable steps to either pay the debt or put my company into some sort of, you know, administration process, but I couldn't do it for these reasons. We don't know yet. I haven't had any cases on this issue as to what the ATO would accept as reasonable steps and what they wouldn't, but obviously each case is, you know, considered on its own merits. But there is that option there to say, look, I did take these steps, I tried to do these things, and I couldn't for these reasons. And then the last one is relating to the Super Guarantee Act, which is when if you don't pay your super, pay your employees super, and then you get hit with a charge, it's around about that. The defence is that you took all, again, sort of a reasonable steps quite defence, where you say, I took all reasonable steps to deal with this for X, Y, and Z. So we had a bit of a chat, Alice and I, about this. It might be that you thought you'd paid it into the right account, but you hadn't, so you shouldn't suffer a penalty, or there was a self-managed super fund. It was all a bit complex. You know, these are the sorts of things that might come up. I think the illness or, you know, reasonable steps defence would probably use more, but that is a third defence that is available. So really important to be aware of those options as well, if you can't deal with the notice for some reason, that those defences are available. So I'll just hand over to you, Alice, back to you, Alice, on garnishee notices, because as I said at the beginning, that was something that the ATO said they are doing a lot of as well, and we need to know, what does that mean? What could that mean if a company or an individual is issued with one of those?
No, absolutely. Thanks, Prue. And I will say that I think garnishee notices are quite simple for the tax office to issue. They are pre-COVID were very much flavour of the month as well. The tax office likes issuing garnishee notices because it means they can get payments against debt that can't be then attacked as preferences by liquidators or bankruptcy trustees. So it can be quite a positive outcome for the tax office. But basically, the tax office has the power to issue a garnishee notice to a third party who owes the company or the director, if it's an individual situation, money, demanding the payment directly from that party to the ATO. So basically, if you have debtors in the company, they can issue garnishee notices to the debtors for them to pay outstanding amounts to the tax office. There might be that there is funds in bank accounts that the ATO can issue notices, garnishee notices to take advantage of those funds. It also could be for individuals if they are in employment. The tax office can issue garnishee notices to the employer to basically start carving out a portion of their wage that could then be paid directly to the ATO to pay down some of the outstanding debts that are there. So I think it's interesting to note, it's one of those things that can come across very quickly. We've had people who sort of have turned up to us because they can't access funds. They thought that they had, debtors coming in, and that would then, provide enough working cash flow, and then that's just dried up. All of a sudden, so they don't actually have access to that cash to trade the company, and therefore, questioning whether they're trading whilst insolvent because they can't on-pay those amounts as well. So it's just something that I think people need to be aware of, because without early intervention, and sometimes with a head in the sand approach, this can happen. As if all other engagement has failed, this can happen without any notice, and it can obviously be quite devastating.
Definitely. Thanks, Alice. And I think that leads on really nicely to our last slide, which is sort of practical tips and tricks. And like we said throughout, you know, we really encourage directors to act quickly. Don't put your head in the sand, because it won't go away. Obviously, you know, the ATO have said they're ramping things up. And the 21 days, it's really important to note that runs from the start of the date of the notice. So if for some reason you haven't seen that notice for a week, it's not 21 days from when you read it, it's 21 days from the date. So it's really important to look at the date of the notice and act really quickly, because it could be, you could run out of time. And the other important thing is to make sure your address on ASIC is up to date, because the address on the ASIC register, so when you do a Creditor Watch company search, it has the obviously the director's address, company address, etc. So the director's address will be the address that they serve the director penalty notice to. So if you haven't updated that and you don't receive it, that is not, it's been held that that's not a valid defence. It's the onus is on you to make sure that's up to date. We'd also say always lodge even if you can't pay, because then it gives you more options. Obviously, deal with it at the early stage is even more important. And I'll come back to the Creditor Watch sort of reporting at the end. But Alice, you had some interesting tips about the ATO portal and communications from the ATO.
Yeah, look, absolutely. And I think from my perspective and what I've been seeing is the ATO is using so many different channels for communication at the moment. So not only is it important to have the registered address, etc., up to date on ASIC and even know where it is. Make sure if you've changed accountants and your registered office is at, you know, that address, make sure you know where that's going so you can check in with that address. But make sure your details are up to date with the tax office as well, because the tax office can communicate in any number of ways. They might just call you on the landline if anyone still has one. They can send SMSs. They put messages in your MyGov inbox as well. I know that, I mean, I'm guilty around tax time of thinking that, oh, well, there's a notification, it's just the notice of assessment, or it's just, you know, we've had our vaccinations, it must be the vaccination. But just be aware and make sure you go in and look at your MyGov notifications, because it could be that the tax office is trying to communicate with you there. But also the portal. We've had quite a few people who have told us that before they've even been physically served with the DPN, it's popped up as a notification on their ATO portal. So be aware and just make sure that you're looking at all of those places and make sure that those details are up to date, because if you get a warning letter, then you can act early. You know, if you know that things are happening, or, you know, you can act. But if you don't have, you know, the mode of communication to get the warning letter, then the first you might hear about it is a lockdown DPN. And at that point in time, it can be, you know, it can be quite, the options available to you are very limited.
Yeah, definitely. Thank you, Alice.
Pardon me. The other point to make there that I think Claire O'Neill from the ATO conveyed in the webinar with Patrick was that it's never too late to take action. The ATO isn't this, you know, horrible big behemoth that needs to be scary. They will make every attempt to work with you to help you pay your debt.
Absolutely.
Yeah, absolutely.
And we've seen that in the last couple of years in particular, but even now, and it might be, and I mean, this is probably for another day, but just because you've got a director penalty notice and there's a personal liability, there are still steps that need to be taken post that, you know, in order for an individual to become bankrupt or what have you after that. So engagement with the tax office, you're exactly right, Michael, is imperative through that entire process.
Yeah, no, definitely. And just, yeah, to obviously to end, just Michael, you spoke about at the beginning about Creditor Watch reporting on ATO tax defaults. So this has been focused on obviously advice for directors, but also there'd be a lot of credit managers, finance managers on the line. You're probably very aware that Creditor Watch do report on ATO tax defaults, and they were the first ones to do so. And it's, yeah, I mean, having a look at it, it's very helpful. So that there are certain criteria, which is the debt has to be more than 100,000, and like you were saying, Michael, that might you know, decrease, and the ATO, you know, said that as well in time. But at the moment, it's 100,000. You have to have an ABN. The debt has to be outstanding for more than 90 days, and no current complaint. And the Creditor Watch searches also have that cross directorship check as well, where you can sort of see if there's a number of different companies that might owe ATO debt. So it's a really good, risk management tool to have that search to see if there's a company you're wanting to do business with and give them credit. Get a creditor watch search to see if there's debts owing to the ATO. So I think that's a fantastic initiative that's been brought in. So
Thanks,
yeah.
Prue. Yeah. So just so everybody knows, so when they go into their dashboard, if a company has been reported on, that will appear in the credit report, and also if a company on your watch list has their debt disclosed, you'll receive an alert, an automatic alert there as well. So definitely be alerted when they come up. Now, we've had a couple of questions come through for Prue and Alice, so we'll just address a few of those if that's okay with you, if we can keep you for a little bit longer. Somebody has asked, if a company hasn't lodged, how does the ATO know what is owed?
Alice, do you mind answering that question?
No, that's fine. The ATO has a lot of, as I said before, has a lot of powers. They have a lot of power to make default assessments. So the fact that you haven't lodged doesn't mean that they can't, take in information that they've had through their notification with. They trawl through social media. They look through the press. We've had matters before where, there's been a big property sale announcement that's been detailed in the Financial Review, and the tax office on the back of that has actually gone and made inquiries about tax reporting on there. So there's default assessments made on, potentially previous years, other information that is available. I mean, it's pretty hard to get around information getting to the tax office.
Now, another question, getting back to sorry, did someone have something to add? I just think
it's a very good question.
Yeah. Thank you for that. So just a question, getting back, Alice, to your comments before about the small business restructuring framework. The person asked, does the restructuring practitioner need to be a registered liquidator? I thought there are restructuring practitioners that are not registered liquidators.
They're still registered liquidators, but they're actually a separate subset. So people like me who are registered liquidators and have the entirety of the designation can do small business restructuring. There is also a subset of the registered liquidator designation that is for small business restructuring practitioners. So they're still registered liquidators, but only allowed to do that carve out. Similarly, there's one for receivers and only allowed to do that carve out. But overall, it's a registered liquidation. Yeah.
Great. Okay, I think this one's for you, Prue. We have directors in Australia and New Zealand. Would a notice be issued to all directors or just the Australian directors? Obviously not planning to have one issued at all, but just wondering what would happen in this instance.
That actually is a good question. I don't know the answer. Do you know the answer to that, Alice? I only thought it would be in respect of Australian companies.
If there's a nexus, I know that we've had bankruptcies before of people who are in New Zealand because there's the business nexus with Australia. So I think, when you talk about liability, we're really worried about at the end, in my view anyway, in terms of bankruptcies and that sort of thing. And I think if there is a business nexus with Australia, then you can still bankrupt somebody irrespective of where they are.
Yeah.
But you're the lawyer. That's just my experience.
Yeah.
Okay. Thank you for that. And one last question. Can a lockdown DPN be issued after a liquidation starts or after a liquidation is finalised? And then can the company's ABN or ACN be deregistered?
Yeah. I think you would agree, Alice, yes, because, they're separate things. So once you get, the lockdown is, that's a separate thing. There's a personal liability. You can still wind up your company, all those sorts of things. And sorry, the next question was then could the company be deregistered? Was that the question? Sorry.
Yeah. Can the company be deregistered? Yeah.
I think Alice, it can. I think we're talking earlier about parallel debts as well. So once the director penalty is invoked, it is a debt of the individual and it is a debt of the company. So if the company goes into liquidation, it's basically a terminal event. Once that has happened, the company is deregistered, the ABN and the CAC can be cancelled at that point in time, but that doesn't extinguish the debt owing by the director through the personal liability regime, which still can happen. And we advise on this in terms of if there's a non-lockdown situation but a notice hasn't been issued, it's not going to help. The liability is still there, irrespective of whether the notice has been issued or not.
Sure.
Definitely.
Great. All right, thank you. There's a couple more questions, but we'll get back to you after the webinar with the answers to those. We'll pose those to Alice and Prue afterwards. We just have a quick poll question. If you could just tell us whether or not you'd like us to get in touch with you to find out more about our tools for managing director penalty notices. As I mentioned earlier, we've got the information on our ATO information on our credit reports and our monitoring and alerts. So we'll give you a minute or so to answer this. Thank you. All right, thank you for that. All right, well, thank you for that, ladies. Now, if you'd like to find out more about the Creditor Watch business risk management system, as I mentioned at the beginning, we have tools available that run from customer onboarding through to due diligence, risk analysis, and finally debt collection tools. Get in touch with us at creditorwatch.com.au, and there's also an option there for a free demo. One of our friendly customer service people can help you out with a free demo. But thank you for attending, and if you'd like to get in touch with Prue or Alice, their details are here. We'll send through the slides so you can have, if you don't catch the number or the email address there, you can get that when we send it through. But Prue and Alice, thank you very much for joining us. That was a great webinar. I really appreciate your time today and answering all the questions.
Thanks, Michael.
No worries.
Pleasure.
Enjoyed it. Thank you. Hope everyone got a lot out of it online as well. So thank you.
Sure they did. Thanks very much, and we'll see you again soon.
Thank you.
Thank you.